Mr. Carly. All righty. There's someone at the door, sir. I don't know if they're waiting for us. Oh, okay. Thank you. So good afternoon. The time is now 1:59 p.m. We're back on the record. And Mr. Monahan, were you finished with your questions?
I am finished.
Thank you very much.
Thank you.
And Mr. Carly, do you have any redirect for Lieutenant Dwyer?
Yes, I do.
Please
Thank
go
you.
ahead.
Thank you, ma'am. Detective Lieutenant Dwyer, good afternoon. Could I ask you first to please turn your attention to Respondents 18, Exhibit 18, page R0500.
I'm there, sir.
All right, sir. Do you recall a series of questions under cross-examination where certain portions of your report here, portions of paragraph 21, were read to you?
Yes. And
you were asked if they were read accurately?
correct.
All right, sir. For completeness, could we go to the fourth line down on page R0500, starting with the sentence regarding?
Yes.
You see the word regarding?
I do.
All right. I'm going to read some of these sentences and just ask if I'm reading them correctly, sir. Regarding the information about the investigation that he texted, Trooper Proctor told investigators that he did not provide specifics besides the name of the decedent. While he may not have provided other specific case information to this friend group, he still provided information, including the cause of Mr. O'Keefe's injuries, that had not been released publicly. Did I read that correctly, sir?
You did.
All right. And continuing at that same point with the next sentence. The comment Trooper Proctor sent about Miss Reed being a, quote, whack job cunt, unquote, is an inappropriate and derogatory comment that shows Trooper Proctor had a personal dislike of Miss Reed. Trooper Proctor testified that his comments were partially due to his emotions getting the best of him. Police officers have to act impartially and not based on emotion. However, police officers still experience emotions based on what they are exposed to. While this is understood, it is also understood that the emotions a police officer may feel about an individual are kept in check and their actions are based on reason and fact. Did I read that correctly, sir?
You did.
Continuing with the remainder of what you wrote in that paragraph, a few more sentences, sir. Did you also write, there is no evidence to show that Trooper Proctor's personal feelings influenced the actual evidence of the case, but the language used to describe Miss Reed is offensive and created the appearance that he was not impartial. Did I read that correctly, sir?
You did.
Continuing. Trooper Proctor's comments about Miss Reed, quote, excuse me, I'll restart that sentence. Trooper Proctor's comments about Miss Reed having, quote, a weird Fall River accent, though, no ass, unquote, are inappropriate as they are a commentary on Miss Reed's appearance and mannerisms. Again, these comments are offensive and created the appearance that he was not impartial. Trooper Proctor's comments, quote, she's got a leaky balloon knot, unquote, and, quote, leaks poo, unquote, are commentary on Miss Reed's medical conditions. In his interview with investigators, Trooper Proctor acknowledged that the comments were unprofessional and regrettable. Not only are the comments offensive and unprofessional, but they are also medical issues that he disclosed to a group of people who were not privy to them. Did I read that correctly, sir?
You did.
And that was the complete portion of that paragraph, beginning with the word regarding and going all the way to the end of the paragraph.
Correct.
If I could ask you to turn your attention a few pages later to R0503. Do you see paragraph 30 on 0503, sir?
I do.
And it's fair to say you were also asked a series of questions about part of what you wrote in this paragraph.
Yes.
All right, I'm going to ask you to follow along, and I'm going to read aloud from this document, and you tell me if I read it fully and correctly, sir. After reviewing the testimony provided by Trooper Proctor related to the text messages about Miss Reed that Trooper Proctor sent, as well as information he provided to investigators, and considering the ramifications of his actions, it is clear that Trooper Proctor's behavior was unprofessional. His actions created an image that he was not impartial in his dealings with Miss Reed. It is entirely reasonable that a police officer may have personal feelings about an individual, but a police officer must act solely on fact and reason. While there is no evidence to show that the police actions taken by Trooper Proctor were directly influenced by his personal feelings about Miss Reed, his conduct demonstrated that he acted in an unprofessional manner that was demeaning to Miss Reed and cast the department into disrepute. Is that the entirety of that paragraph, sir?
It is.
Thank you. Now, sir, in the same set of documents, again, respondents' exhibits, the binder you have in front of you, could I ask you to please go to R481, please? R0481. I believe it is 15, sir.
15?
Let me confirm, please. I said 15. Let me confirm, please.
It is actually 15.
Thank you. Thank you, Madam Commissioner. All right.
Okay, I'm there.
0481, sir, Exhibit 15. I want to ask you, before I refer you, first of all, what is Exhibit 15, just to clarify for everyone?
It is a transcript of the interview that we conducted with Trooper Proctor.
And this would otherwise be known as the OPIA interview conducted in this case?
Yes.
As part of your investigation?
Correct.
Okay. And I think earlier you testified, and correct me if I'm wrong, this interview was audio recorded?
It was.
And it was also then reduced to this transcription as well?
Correct.
During the course of your entire investigation, not just this interview, when, if ever, did the discussion or the topic of the February 8th, 2024 meeting between Michael Proctor, his attorney, and members of the department, when, if ever, during your investigation did that subject come up?
To me, during this interview.
All right. To your knowledge, or as in your training and experience, and given your entire knowledge of your entire investigation, Is it your belief that this is the only place in your investigation where this subject came up?
Yes.
Okay. And with respect to these pages of the transcript, starting with 0481, there's a series of questions, both by yourself as investigator, a fellow investigator, and counsel for Mr. Proctor on this page and the next 2 pages. Is that accurate?
Yes.
All right, sir. And referring you specifically to 481 through 483, this is the part that you were referring to where this subject came up, sir?
It is.
All right, sir. And just with respect to the introduction of the subject, starting with line 4 of 481, I'm going to read it aloud, and again, if you would tell me if I read it accurately, sir. Question. So you said on February 8th, 2024, you met with Attorney Staples and Kelly and DeStefano about the text messages. Was this a breakdown of all the text messages within your phone, or just what was brought up at trial, essentially? And then at line 9, the transcript indicates Attorney Moynihan says, this was in February of 20, and then it cuts off. And continuing with line 11, you state this was after the grand jury. In terms of lines 4 through 11, did I read that accurately?
You did.
All right. Continuing on, sir. The line 12 begins with question after grand jury, yes. Is that accurate?
Yes.
And then there's some back and forth between, on lines 13 through 18, there's some back and forth and some crosstalk between yourself and Attorney Moynihan. Is that accurate?
Yes.
All right. And reading the portions of lines 15, 17, and then 19 through 22, your question that's next stated is effectively as follows. And again, please tell me if I misquote anything. Question, but I mean, now he knows what was brought up in trial, so what you learned at that meeting, was it just a discussion of essentially what then came out in trial, or was it about a lot of text messages, other text messages? Did I read that accurately?
You did.
Then, beginning with line 23, there's an answer from Michael Proctor. Answer. So that February meeting was after I testified at the federal grand jury. And it was a discussion about the messages, how they were unprofessional and how they could potentially be interpreted. We decided to go into content. I've ended there at midway through line 2. Is that accurate?
Yes.
All right. And after Trooper Proctor indicated in that statement that he had decided to go into content, he takes it a different direction and says, I mean, we, Attorney DeStefano and I can't remember specifically what I shared, but they didn't really want to hear the full content at that time. We provided some examples, but we didn't go through like every single text. Did I read that portion of lines 2 through 7 accurately, sir?
Yes.
Then picking it up again with line 8, question. They didn't have a breakdown of every text. They just had what was presented at, and then you're cut off. And Mr. Proctor answers on line 10, not to my knowledge. I didn't know if they, and he's cut off, and there's some crosstalk. And picking up with line 12 with Trooper Proctor's answer, if, yeah, I don't know what was provided to them at, you know, what point. Did I read that accurately, sir?
You did.
All right, sir. And then on line 14, Attorney Moynihan, based on the transcript, interjects by saying, I have a question if you're done. Did I read lines 14 and 15 accurately?
You did.
And then the answer comes back from Detective Lieutenant Sweeney on line 16, yes, I'm done. And then the questions pick up in the transcript, starting on line 17. The questions now for this next portion are questions posed by Attorney Moynihan. Is that accurate according to the transcript?
Yes.
All right, beginning line 18, now under questioning from Attorney Moynihan. Question. At some point thereafter, did they get the specific text messages? Answer. Yes. My understanding is question. in March. Answer, correct, sir. And then a question is interjected by a different participant, Detective Lieutenant Sweeney, on line 23, who got the text messages? Question, again referring to Attorney Moynihan, the legal department. Then Detective Lieutenant Sweeney interjects another question on line 25. All of them? Did I read that accurately through line 25, sir?
You did.
All right, and the last few lines here, sir. Beginning at the top of 483, beginning with line 1. Question, again referring to Attorney Moynihan. That's what you were told, correct? Answer, yes. I was informed that by Attorney DiStefano that MSP Legal met with ADA Lally and ADA McLaughlin was read in the full content of the messages. Then on line 6, sir, you interject. Yes, I think for clarification purposes, the department didn't receive anything. They were verbally told, and then you're cut off. Michael Proctor answers on line 9, correct. And your question continues, or your statement continues on line 10. What was the content of the messages? And on line 12, Michael Proctor answers, that's my understanding. Did I read that accurately, sir?
You did.
All right. Other than that portion of the transcript and that portion of the interview, do you have any personal knowledge as you sit here, sir, of what took place in the meeting between Michael Proctor, his attorney Michael DiStefano, Major Kopenrath, and staff from State Police Legal? Do you have any knowledge of what took place in that meeting, other than what comes from this portion of the transcript on February 8th of 2024?
I do not.
All right. So in terms of questions that you were asked on cross-examination about, well, you weren't aware at the time, but you're now aware of that. Do you recall those questions, sir,
I
in
do.
that form?
Yes.
The answers you gave to those portions of the questions, or those questions posed to you on cross-examination, did those come from your personal knowledge or from essentially hearsay and rumor around the department?
It was from rumor.
All right. And those answers you gave to those questions, that was not based on any investigation that you performed. Is that accurate?
Correct.
All right, sir. I want to switch topics now and ask you about a series of questions you were asked on cross-examination concerning the timing of the duty status hearing for Michael Proctor. Do you recall a series of questions on that subject?
I do.
All right, sir. I want to ask you, before getting into the specifics of the timing of the duty status in this case, some general questions, if I may. First, you subjects of, based on your training and experience as an internal investigator for OPIA within the Massachusetts State Police, you subjects of internal investigations by OPIA have certain rights under the collective bargaining agreement and Massachusetts Department rules and regulations.
Yes.
All right. And in fact, during cross-examination, is it correct to say that you were asked a series of questions by counsel about some of those rights?
Yes.
You recall questions and answers related to due process rights of the subject of the investigation, things of that nature?
Yes.
All right, sir. Is it fair to say that some of those rights come into play once a subject is brought forward for a duty status hearing?
Yes, that would be accurate.
Okay. And if they have their duty status changed, if a given member has their duty status changed, based on your training and experience, do some of those rights under the CBA and under Massachusetts State Police regulations kick in at that time?
Yes.
All right, and would one of those rights be presenting the subject with evidence of the misconduct that is the basis for the allegation so that they can defend themselves during the disciplinary process?
Yes.
All right, sir. And you know that to be a right that subjects of internal investigations that you've pursued have in your investigation?
Yes.
And you also know that Michael Proctor had that right as well as one of the subjects of one of your investigations?
Correct.
Did you, or to your knowledge, did anyone at the Department of Massachusetts State Police have documentation, physical evidence or documentary evidence of the alleged misconduct, the alleged text message misconduct, either at the meeting in February 8th of 2024, or the Colonel's meeting that you mentioned before, March 4th of 2024?
None that I'm aware of.
All right. And based on your understanding of the non-disclosure agreement that you described previously in your testimony, were you permitted to do anything with that information other than open an internal investigation at that time, meeting March 4th of 24?
No.
All right. Had any documentation as of March 4th of 2024, had any documentation been provided to you or to your knowledge anyone else within the department underlying the allegations of inappropriate and disparaging text messages by Michael Proctor?
No.
So there was no documentation provided to you?
Correct.
And you were the assigned investigator in that matter?
Correct.
Would, if documentation had been provided and shared with the department, would it have come to you as the assigned investigator?
Yes.
Based on your understanding of the NDA, were you allowed to share even the existence of the allegation of inappropriate text messages outside of the group of people who signed the NDA?
No.
When was the first time, sir, as the assigned investigator, when was the first time that you received actionable information and details about that alleged misconduct by Michael Proctor via the text messages that allowed you to move forward with your investigation?
When Trooper Proctor testified at the criminal trial.
As you understood the NDA, sir, you were not in a position to move forward with your investigation until you received Michael Proctor's public testimony about his conduct.
Correct.
And the department could not bring Michael Proctor forward to relieve him of duty, whether it be restricted duty or suspension with or without pay. It could not do so until it could provide the subject with documentation to support the accusation of misconduct.
Yes.
All right, sir, I want to ask you about the charges. You were asked a series of questions about Article 5. Do you recall some questions about that, sir?
I do.
All right. I'd ask that you go, please, to Article 5, which is Respondents 24.
I'm there, sir.
All right. And for council and the commission's benefit, that's R0642 is the first page. All right, sir. You have, let's call it 0642 is the cover page, 0643 is the first page of content from Article 5.
Yes.
Okay. Could you read? It's a very short. It's a very short thing, but just 5.1, if you could read, not 5.1.1, just 5.1, please.
5.1 is titled Violation of Rules. Members and civilian employees shall not commit nor cause to be committed any acts or omit any acts which constitutes a violation of any Massachusetts State Police rule, regulation, policy, procedure, order, or directive.
All right, sir. And could I refer you then to R0644, the next page, specifically to 5.3. Do you see 5.3 general conduct?
I do.
Could you just read very briefly that one sentence, general conduct?
Members shall maintain a level of conduct in their personal and business affairs which is in keeping with the highest standards of the law enforcement profession. Members shall not participate in any act which impairs their ability to perform as members of the state police or causes the state police to be brought into disrepute.
Now I'd ask you to please, to drill down on this a little bit more. Please go to R0645. page 3 of that particular document. Do you have 0645, sir?
I do.
All right, looking down at the bottom of 0645, 5.8 is titled unsatisfactory performance, is that right?
Yes.
And 5.8.1, could you read 5.8.1, please?
Yes. Members shall maintain sufficient competency to properly perform their duties and assume the responsibilities of their positions. Members shall perform their duties in such a manner as will maintain the highest professionally accepted performance standards in carrying out the functions and objectives of the state police.
So, could you then continue on to the next page, R0646, excuse me, R0646, 5.8.2. You were asked a series of questions about 5.8.2 in particular as well, is that right?
Correct.
Could you just read for us the complete text of 5.8.2, and then I'll have some follow-up questions.
Unsatisfactory performance may be demonstrated by a lack of knowledge of the application of laws required to be enforced, an unwillingness or inability to perform assigned tasks, the failure to conform to work standards established for the member's rank, title, or position, the failure to take appropriate action on the occasion of a crime, disorder, or other condition deserving state police attention, or by an absent without leave.
Thank you for reading that, sir. Series of questions for you about 5.8.2 in particular. Understanding your earlier testimony that you are not assigned responsibility for what charges are brought during the disciplinary process. You're only assigned to the investigation and to either sustain, not sustain, or exonerate on each individual allegation, factual allegation. Understanding that, sir, do you see the portion of 5.8.2 that says unsatisfactory performance may be demonstrated, and then it proceeds from there?
I do.
All right, sir. Is it your understanding that unsatisfactory performance may be demonstrated? What follows is a list of possible ways in which 5.8.2 can be violated?
Yes.
All right, sir. It is not your understanding that that is an exhaustive list?
Correct.
All right, sir. With respect to the questions you were asked about 5.8.2, do you recall a series of questions on cross-examination where you were asked to go down and after each one of those clauses, or each one of those sections under 5.8.2, you were asked, did you find any, effectively you were asked, did you find any evidence in your investigation to suggest that Michael Proctor violated this portion of 5.8.2? Do you recall that series of questions?
I do.
Did I characterize those fairly, sir?
Yes.
In your view?
Yes.
With respect to your answers to those questions on cross-examination, sir, can you explain how you were answering those questions? What did you mean by your answers when you did not find anything with regard to Michael Proctor's performance of his duties as a Massachusetts State Police detective assigned to Norfolk County?
Yes. So my investigation was focused on the allegations over the text messages. It was not on any aspect that Trooper Proctor took in furtherance of the criminal invest. So when I was answering those questions, I was referencing the fact that during my investigation, I learned nothing to suggest that any of his actions impacted any of the investigative steps taken during the invest.
All right, sir. Does it therefore follow from that testimony, sir, that you are saying that there's no evidence of a violation of 5.8.2 at all?
No.
Okay. With respect to, for example, in 5.8.2, failure to conform to work standards established for the member's rank, title, or position. With respect to that, going beyond just the specific investigative steps that you're aware of or became aware of during the course of your investigation, are you aware, based on the conclusions of your investigation and the evidence gathered, of a failure to conform to work standards established for the member's rank, title, or position in that broader sense of Trooper Proctor's duties?
Yes.
And earlier you asked, or you were asked a series of questions regarding your familiarity with Article 5, this document here, Exhibit 24. Do you recall being asked about your familiarity with Article 5 in general?
I do.
All right. And with respect to your familiarity with Article 5, it's fair to say that all members, not just internal investigators, are required to be familiar with Article 5. Is that an accurate statement, sir?
Yes.
All right. With respect to all members being familiar with Article 5, and your knowledge of Article 5 in particular, sir, is there any portion of the sections we just read or any portion of Article 5 that says members shall conform in the following way except when on a personal cell phone?
No.
Does it say except when texting with one's high school friends?
No.
Does it say except when you're stressed or angry at a suspect?
No.
All right, sir. I want to change gears, if I may, and ask you a series of questions with respect to the interview that you referenced earlier. The interview of Michael Proctor took place July 19th, 2024. Is that accurate?
Yes.
Do you recall a series of questions on cross-examination from Mr. Moynihan, from Attorney Moynihan, about the timing of setting up that interview, and specifically a conversation you had in conjunction with the duty status hearing?
I do.
All right, just to refresh everyone's recollection and the commission's recollection, what was the date of Michael Proctor's duty status hearing in this case?
It was the first.
Well,
July 1st.
so the administrative leave went through on July 1st.
Yes,
Is
the 12th, I
Sorry,
believe.
sorry. The administrative leave went through on
July 1st?
Yes.
Okay. And the actual duty status hearing didn't occur, and based on scheduling issues, didn't occur until July 8th of 2024.
Correct.
Is that accurate?
Yes.
Okay. With respect to July 8th in particular, do you recall a series of questions from Attorney Moynihan with regard to your attempts to speak with him at or around the same time as the duty status hearing, and asking him to set up a time for Michael Proctor to come in and give the interview?
I do.
All right. And sir, you were also asked a series of questions about your motivations and how much emphasis or how much importance you put on the timing of getting that interview done quickly.
Yes.
And you were also asked about how common it was, for example, for you to go to, for example, the counsel of a subject of an internal investigation at the duty status hearing in an effort to set up the duty to, that's a terrible question, pardon me, I'll start over. Do you also recall a series of questions asking about how common it was for you to approach counsel for a member at a duty status hearing to set up the interview?
Yes.
And you acknowledge that it may have happened before, but it is somewhat unusual to do so.
Correct.
Can you explain why it happened in this case, sir?
Yes. So typically, when someone gets their duty status altered, that typically happens at the beginning of the investigation. In this case, that did not happen. The investigation began in March. I learned of the content of his text messages when he testified in the trial in June. At that point, I started my analysis of the text messages to include the analysis of his pay station records at his ABL. At the time of his duty status hearing, my investigation, the bulk of it had been completed. The only piece that I had left to do was to interview Trooper Proctor. So when I approached Attorney Moynihan, it was an effort to get that interview going.
Let me ask you a couple follow-up questions, if I may there, sir. When you said you had completed every other step of your investigation except for the interview of Michael Proctor, did that include some of the exhibits we saw in your testimony yesterday? For example, your collection and analysis of the ABL data, your collection and analysis of the pay station reports, things of that nature?
Yes.
Those were all complete as of July 8th, 2024?
Yes.
In fact, every part of your internal investigation was complete as of July 8, 2024, with the exception of the interview from Mr. Proctor.
Correct.
Was there any reason to wait to schedule the interview of Mr. Proctor, given that you were at that stage of your investigation on July 8, 2024?
There was not.
All right, sir. Switching gears once again, I only have two more topics to ask you about. You were shown under cross-examination a series of emails that you shared with a fellow OPIA investigator, the chief of OPIA, Lieutenant Colonel Shoemaker, and Suzanne Caravaggio from the state police. Is that accurate?
Yes.
And there were a number of emails, including emails presented to you from July 17th of 2024 in particular. Do you recall those emails?
I do.
All right, sir. And do you recall being asked a series of questions by counsel for the appellant with regard to the different permutations or versions that your report went through in July, around the time of July 17th, 2024?
Yes.
And one of those, you were asked a series of questions about a new version of your report from the afternoon hours or the PM hours of July 17, 2024, that included preliminary recommendations as to each allegation as you put forward in that draft of the report at that time. Do you recall that?
I do.
All right, sir. And do you recall a series of questions about whether or not you had reached premature conclusions in this case?
Yes.
All right, sir. Commissioner, may I approach, I handed it up earlier in the hearing when this topic came up before.
This was the two-page document.
The two-page document, yes.
I have it right
May you have a copy? May I approach the witness with a copy?
here. Do you have an additional?
I do have an additional.
So are you going to send it as an exhibit?
I was just going to ask Detective Lieutenant Dwyer to authenticate it,
Yes.
and then I would be offering it as an exhibit, yes.
Please go ahead. Please go ahead.
Thank you. May I approach counsel and the witness? Thank you. Sir, handing you a two-page document, can you just take a look at that for me, please, and tell me if you recognize what you see there?
It was an email that I sent.
All right. And the date of this particular email is July 17, 2024, and specifically sent at 9:05 p.m. and 14 seconds?
Yes.
All right, sir. And if you could just look at both pages and tell me, based on your awareness and your personal knowledge, is this do these two pages fairly and accurately reproduce the content of this email chain as it existed at that time?
Yes.
All right. I would ask that this be, would it be exhibit, Respondent's Exhibit 37?
Can you tell me who Jeremy Sweeney is again?
Sir, would you please tell the
Jeremy
Commissioner who
Sweeney.
Jeremy Sweeney
He was a DOT that was assigned to OPIA.
Okay, thank you.
All right, sir.
And
I'm going to refer this, I apologize.
I admit that is Respondent's Exhibit 37.
Thank you, thank you. I'll now refer to it.
Sorry. Thank you very much.
I'll now refer to it as Exhibit 37, sir, for clarity. On Exhibit 37, is it fair to say that this particular email was drafted after you had submitted within OPIA the new version of your draft, which contained those preliminary recommendations?
Yes.
Or preliminary conclusions, is that a fair way of putting it?
Yes.
Okay. And is Exhibit 37, and specifically the two lines at the top that you added at 9:05 p.m. that evening, is that by way of explanation for the new version of the draft?
It is.
Could you please read aloud the entirety of those two lines, please?
Yes. Also, and obviously, the recommendations are only based on what we know so far, and it's just a draft. They may be changed based on what we learned from Proctor.
Now, sir, I want to move slightly ahead of Exhibit 37, but related questions. The interview of Michael Proctor took place July 19th, less than 2 days later after this email was drafted.
Yes.
All right, sir. And as of July 19th of 2024, following the interview, did you take it upon yourself to conduct a summary and analysis of what Trooper Proctor told you and investigators in that interview?
I did.
Did you, in fact, update your report to include the content of what Trooper Proctor stated during that interview?
I did.
And did you also check the earlier versions that you had entered into the draft copy of the report, the boilerplate that you mentioned before? Did you check that for accuracy?
I did.
did you also have occasion at that point to analyze and incorporate Michael Proctor's testimony into your findings and conclusions in your report?
I did.
Now, do you recall a series of questions on cross-examination about how the draft copy of your report existed as of July 17, 2024, a couple days bore the interview, and the final version as it ultimately ended up? Do you recall a series of questions about that?
Yes.
Do you recall questions specifically directed to you as to whether or not any of your recommendations changed after the interview with Michael Proctor?
I do.
All right. Can you tell us why none of those recommendations changed after the interview was complete?
Nothing was learned in the interview that changed the facts as we already had them. For the most part, Trooper Proctor had confirmed basically what he had testified to. So the sustained charges were kept. In addition, he also confirmed the charges that we did not sustain as well.
During your interview, did you have occasion to ask clarifying questions or additional questions that were not necessarily asked during his public trial testimony?
Yes.
And did you consider those questions of importance to you in your investigation?
Yes.
And with respect to those questions, were you seeking additional information and insight as to whether or not Trooper Proctor's, each individual allegation against Trooper Proctor was accurate?
Yes.
Or was supported by evidence?
Correct.
And you had the opportunity to ask all of those questions and Trooper Proctor answered them?
Yes.
All right. And did, in answering those questions and clarifying your questions as an investigator, in clarifying the answers to your questions as an investigator, did Michael Proctor give you in that interview any reason to change any conclusions that you had reached as a result of what you knew going into the interview?
No.
All right, so last topic, if I may. Under cross-examination, you were also asked a series of questions with regard to Michael Proctor sharing information about the active homicide investigation with individuals outside of law enforcement. Do you recall a series of questions about that?
Yes.
All right. And do you recall being asked if you looked into whether or not certain individuals knew certain facts as of, for example, the evening of January 29, 2022 at around 10:30 p.m.?
I do.
And you recall stating in your testimony that it was not relevant to your investigation what the pre-existing knowledge of those other individuals was.
Correct.
Can you tell us why it wasn't relevant to your investigation? What they did or did not know at that time?
Because my investigation was focused on whether Trooper Proctor was authorized or not to send that information, not based on what someone already knew.
All right, sir. As a reminder to the Commission, I know you touched on this in your direct examination. As a reminder to the Commission, who or what is the entity legally charged in Massachusetts with all homicide and unattended death investigations in a given jurisdiction?
The DA's office.
All right, so the local DA's office of jurisdiction is the legal authority by state law.
Correct.
And are troopers assigned to district attorney's offices required to follow the lead of the district attorney or his or her designees in their office for homicide investigations?
Yes.
And does that include following the lead of the district attorney and his or her office as to what is shared publicly with the media?
Yes.
Do you recall testifying in trial court in this matter?
I do.
Do you recall being asked a series of questions under cross-examination at the trial court on this particular topic?
I do.
And do you recall a series of questions designed to elicit from you whether or not you had any information about how public certain information was in the hours following the discovery of John Keefe's body?
Yes.
As a result of being asked about that at the trial court, as the investigator in this matter, did you have occasion prior to today to go seek out additional information to nail down the timing of when the Norfolk County District Attorney's Office authorized the release of certain information?
I did.
Sir, to your, based on the information you tracked down from the source, the Norfolk County District Attorney's Office, when did that office first make a statement about providing any information about the discovery of the deceased John Keefe's body?
I believe it was in the late afternoon of the 29th.
Based on the information provided by the Norfolk County District Attorney's Office and their provision of information publicly, did they, at that time, meaning the late afternoon of the 29th, did they confirm, for example, that the decedent was a Boston police officer?
I believe so.
Do you recall whether or not on the afternoon of the 29th that they had indicated there was an individual found outside the residence, they were taken to a hospital and pronounced dead?
Yes, that sounds accurate.
Do you recall information received from Norfolk County that it was at 3:19 or thereabouts on January 30th before they confirmed that the decedent was a Boston police
Yes.
officer? Do you recall whether or not, when they confirmed that to an outside source, to the public, that the individual was a Boston police officer, did they confirm the identity of the individual, meaning not just a Boston police officer, but specifically Boston police officer John Keefe? Did they confirm that at that time on the 30th?
They did not.
When was the first time that they confirmed additional details, including the identity of the decedent and the arrest of Karen Reed?
It was on February 1st.
As part of that process, and as part of your investigation overall, did you have occasion to look for any information, one way or the other, as to whether or not Mr. Proctor, as of, for example, January 29th, 2022, was authorized by the Norfolk County District Attorney's Office to reveal what he did in those text messages?
Yes.
Did you find any information to suggest that Norfolk County had authorized him to reveal that information?
I did not.
Nothing further.
Do you have anything, Mr. Martin?
Just a few
Very
questions,
briefly.
Commissioner. Just to backtrack, DLT, Michael Proctor was not charged with dissemination of information, was he?
No, sir.
And regarding this non-disclosure agreement, do you have a copy of that?
I do not, sir.
Have you ever provided a copy of that to myself?
I am not.
And do you know if anyone has?
I am unaware of that, sir.
When was the last time you read it?
On March 4th.
And were you weren't given a copy, I presume?
I don't recall, sir.
Do you ever recall having in your possession a copy of that NDA?
On March 4th, I did, yes.
Other than on March 4th.
Not that I can remember, sir.
And so on March 4th, I'm assuming correct me if I'm wrong, you've shown a copy of it
Yes.
and you signed it?
Yes.
You read it before you signed it?
I did.
So your understanding today is what you recall from March 4th of 24, correct?
It is. It was a very clear understanding.
Yeah, and but you haven't seen that document since March 4th?
I have not, sir.
And that's, and as far as you know, it's never been provided to us?
I wouldn't know that, sir.
Now, as part of that process, numerous other people at that meeting were required to sign the NDA as well, right?
Yes, sir.
Colonel Law included,
I would assume yes, sir.
Lieutenant Colonel Connors,
Yes, sir.
and others, Major Caporath, etc.
I would assume yes.
And so they were aware of the contents of the text messages, and they were presumably precluded from disclosing them.
Again, I don't know if they're aware of the contents. All I know is that the people in that room were aware of the existence of the text messages.
Now, you were shown what I believe is Respondent's Exhibit 26 a moment ago. If you could take a look at that, and its bait stamp number. So I think it's 25. Article 5. I'll get to the bait stamp. you can look at respondents' exhibits, 643, which were shown a moment ago.
Yes, sir, I'm there.
And this is Article 5, correct?
It is.
And you were shown the category of discipline entitled unsatisfactory performance, correct? 5.8 on page stamp 645.
Yes, sir.
And you specifically read 5.8.1, correct?
I did.
And you told us that 5.8.2, first of all, that's what Michael Proctor was eventually charged with, correct?
Yes, sir.
You told us earlier that you don't decide what charge Michael Proctor or any trooper is going to be charged with, correct?
Correct.
But you told us that 5.8.2, which is very clear and specific, only lays out possibilities of examples of unsatisfactory performance, right?
Can you ask that again?
You told us on redirect that 5.8.2, first of all, that's what Michael Proctor is charged with, correct?
Yes.
That only lays out possibilities. Recall telling us that?
Yes, sir.
Okay. But 5.8.1 is pretty specific, is it not?
It is. Yes, sir.
And that's the category of unsatisfactory performance, which, as you read, members shall maintain sufficient competency to properly perform their duties and assume the responsibilities of their positions, correct?
Yes.
Members shall perform their duties in such a manner as will maintain the highest professionally accepted performance standards in carrying out the functions and objectives of the state police. Did I read that correctly?
You did.
Okay. And could you go to Respondents Exhibit 26, please?
I'm there, sir.
Date stamp 0669.
I'm ready, sir.
All right. So page 669, date stamp. You see 5.8.1 on the category of discipline and the consequential charge.
I do.
And 5.8.1, the section we just read and that you were asked to read, what classification of discipline is that?
For 5.8.1,
Yes.
it's Class C and D.
It could be a Class C or a Class D.
Correct.
And that's at the discretion of the department/colonel, correct?
Correct.
And so Michael Proctor, if he had been charged with 5.8.1 under the disciplinary guidelines, he could not be fired, could he?
Under that one, yes, under 5.8.1.
That's all I have. Thank you.
Good afternoon, Lieutenant. How are you?
I'm well, ma'am. How are you?
So I have a few questions for you. I'll begin with asking about your background. When did you first join the state police?
In 2004.
And what were your first assignments?
My first assignment was out of Leominster Barracks.
And you were just a trooper?
Yes, sir. Yes, ma'am.
And how did your career advance after that?
From the Lawrence Barracks, I was assigned to the State Police Detective Unit for Worcester County for about 6 years.
Say that slowly. State
The
Detective
State
Unit,
Police Detective Unit for Worcester County.
Worcester County. Okay. Okay.
From there, I was assigned to the High Risk Victim Unit for about 4 years.
That was also in Worcester.
It was a statewide unit.
And what year did you begin that?
It would have been 2016, I believe.
So you were in Leominster for how long?
A little over 5 years.
So then, in
About 5 years approximately.
so then in 2009 you went to the Worcester County.
I was beginning in 2010, I believe.
And then after you left the high risk unit, where'd you go next?
From there, I went to it's called the Public Response Unit.
And that's also statewide?
It's a statewide, it's a unit that's based at headquarters.
Which is where?
In Framingham.
So please no acronyms and just
I apologize.
give me all the late first. So what year did you go to the public response unit? What year was that?
2020.
2020. And you attended the State Police Academy?
I did, yes.
And Lieutenant Dwyer, what is your level of education? Where'd you go to school?
College.
College. Did you do an advanced degree?
No.
And when you joined, when you were at the police academy and after, have you had any trainings since you were hired?
On the state police?
Yes.
Yes.
Investigative trainings and
Yes.
internal affairs trainings?
Yes,
Can you
ma'am.
please describe those?
There's been numerous invest trainings when I was in the detective unit for crime scenes, homicide trainings. I've been trained in sexual assault investigations, human trafficking investigations, multiple IA investigations. There's doing a bunch over the years, but those are the ones that stand out to me now.
When did you become a detective lieutenant?
In 2021.
All right. So I just would like to go over some of the work you did on this matter. So I'll ask you please to turn to Exhibit 19.
The respondent or the appellant?
The appellant, Exhibit 19. So this is case stamp appellant 107.
You said 19, ma'am?
Yes, so it's date stamp, page 107.
Yes, ma'am.
All right. So this is dated June the 26th.
Correct.
So is this product the result of your first draft?
No.
Your first, what is that?
No, ma'am. This product was a result of watching Michael Proctor's testimony at the trial and the notes that I took. This was generated just to draft an idea of what the possible violations would have been.
And this, there was another exhibit where you took the notes as well. This was based on that exhibit where you submitted on just notes?
So those notes probably weren't finalized until after that one. It was this draft here was probably based off of all the hand notes that I took.
All right. Can someone tell me which exhibit was detective's notes on watching the testimony?
I apologize. I believe it was Respondent's 8.
Yes, that makes sense. Yes. Respondent's eight. So you testified earlier that you made those notes Respondent's Exhibit 8, and then this letter later after watching the testimony, live
No,
streaming?
ma'am. The notes that are the exhibit, I don't know exactly when they were created, but they were most likely created after I had drafted that document.
The notes from the video, from watching the live stream?
Yes, the notes are the exhibit. That was my final drafts. It was 2 days of testimony.
Yes.
So I spent 2 days just writing notes down. That is not what is Exhibit 8. The Exhibit 8 is me compiling all the notes that I took while watching the trial.
All right.
I also generated this document here from the handwritten notes that I took from watching the trial.
So I'll just ask you to look at paragraph number 2, which is on page 107.
Yes, ma'am.
So you have at the end of that paragraph that the conduct identified in that paragraph could be, your very last sentence says, this could be a potential violation of rules and regulations 5.23.
Yes, ma'am.
And I believe we said earlier that 5.23 was dissemination of information.
Yes, ma'am.
So I believe that is in Respondents 24. Return to that, please. So that's page 652, Respondents, page 652.
Yes, ma'am.
And as you look at these, it looks like it goes to about 10 sections, 5.231 through 5.2310. Which section were you considering that this could be a potential violation of?
So I'm not qualified to speak which section it is. The purpose of this document was just to highlight the possible violations. So when I pointed out 5.23, I was referencing the fact that those texts could fall under one of those subcategories in the greater category of 5.23.
Okay, so who would be qualified to decide which section it would be after you draft this?
The personnel that are involved in the process to decide discipline. That would be the DST command staff, the legal section, the department prosecutor, among others.
But if you can just please look at that page 652.
Yes, ma'am.
In looking at those sections, I mean, they're quite, I would say, different kinds of acts. Which ones would you think would match that conduct of the text messages being sent out to different people?
I mean, I don't know if I'm qualified to make that call.
How did you choose 5.23?
So I knew that he was sharing information, which would be the dissemination of information. So I know that the broader category, 5.23, the overall one, is the dissemination of information. It would be up to the person who decides the actual charges to go through that category and pick the specific subcategory.
So at the time that you wrote this document, who did you think would be the person to decide that?
So this document was not designed to recommend charges.
Mm-hmm.
This document was just to let my bosses know this is the violations that have occurred. These are what the possible violations may be once the invest is done. This document was generated well before a report was done or I was near the end of the invest.
All right. The same thing on paragraph 3, the same page. The last line says, this could be a potential violation of policy and procedure ADM-47 bias-based policing and ADM-18 unlawful harassment / sexual harassment.
Yes.
And what made you choose those?
Again, based on the nature of the text messages, I was just making sure that I encompassed all possible violations. Again, this document was not meant as a recommendation for possible charges. This was just to document what the possible violations may be as the invest moves forward.
And then on paragraph 4, if you turn the page, the last sentence, this could be a potential violation of rules and regulations 5.10.4.
Yes, ma'am.
And what was your consideration of including that? It's page 108, paragraph 4.
Let's look at the appropriate rule. Because that one specifies that they shall not consume alcoholic beverages. So that one was pretty simple to pin down.
So that was one you decided on your own?
There was no other option for that one, yes.
Thank you. So, the other question I had is, when you're investigating the issue of the text messages and dissemination, did you consider, did you view it as multiple violations?
I did.
Or one violation?
Multiple violations.
How many violations do you think occurred?
Well, so there were 4 separate text conversations. So I viewed each text conversation as its own incident.
So would you consider them, so you're looking at them as 4 separate, so basically 4 separate chains?
Correct.
4 separate dates?
Multiple dates.
Multiple dates.
Correct.
So you were looking at them as more than one offense then? It wouldn't be a first offense? How did you look at it?
For charging purposes?
Yes.
I don't make that call yet.
Okay. I just want to look at one more item. Do you recall this morning that Mr. Moynihan went over with you potential charges that you received from Ms. Cavaggio?
Yes, ma'am.
And do you recall that he described that, if you could turn to exhibit, it's actually Bates stamped 172, I believe it's exhibit 32, appellant's exhibit 32.
Yes, ma'am.
And this is where we have to look at more than one exhibit to get the information. I believe it's also respondent exhibit 26. The danger of double-sided copies. So respondents exhibit 26. Do you see on page 667?
I do.
So there are classes of guidelines,
Yes.
A, B, C, and D.
Yes.
And do you recall this morning when Mr. Moynihan went through dissemination of information, which is 5.23
Yes, ma'am.
and 2, and he went through each clause with you?
Yes, ma'am.
Do you recall that for a first offense, that 5.232 is a class C,
Yes.
and that for a first offense, if you look on page 667, it's a written reprimand up to and including suspension for not more than 5 days,
Correct.
and that's for a first offense.
Yes, ma'am.
I'm not going to look at the alcohol, the 5.10.4, but on the unsatisfactory performance, which is 5.8.2,
Yes, ma'am.
which was in terms of Class A. And do you recall that under the first offense, a suspension of not less than 30 days, but up to and including termination for a first offense?
Yes, ma'am.
Mr. Carley and Mr. Moynihan, was there an ADM 47 admitted as one of the articles?
I don't believe so.
I believe it was produced in December, but I don't believe either party marked it this.
Yeah, it got mentioned in one of the exhibits, but it wasn't submitted. That's fine. I just know I know I read it somewhere. Okay.
I apologize. I don't believe it was marked, but I would be happy to provide it.
Yeah, because it is mentioned, and I was just wondering what it said. So I think that was the ADM 47 that's mentioned. It's mentioned in Exhibit A19 in paragraph 3. And that's what I was trying to figure out what it was. So if one of you could submit that.
I'd be happy to.
Thank you. Excuse me. All right, thank you very much, Detective Lieutenant.
Thank you, ma'am.
May I ask a clarifying question?
Yes.
Only with regard to the Commission's request for ADM 47, which I'm happy to provide.
Yes.
As the Commission may be aware, the Department's policies and regulations go through multiple versions over the years. Is there an effective date, or is there a date range that I should target? I'm happy to submit multiple if necessary.
Well, I would be interested in the one in effect on the date of the letter, which is June 26, 2024. And if it's overly, and actually the second one as well, there's two of them, ADM 18, unlawful harassment / sexual harassment. So they're two documents.
I'll produce both that were effective on this date. Thank you.
Thank you very much. Do you have any further questions for the Lieutenant?
I just believe, I'm just curious if the department's resting. They had one witness.
Right, I think I'm just saying,
I don't have any
based on the questions I just asked, I guess that is what I meant. Do you have anything further for your client?
Nothing for this witness. No.
And Mr. Moynihan, you're rested as well?
I have nothing else for this witness.
Okay. Well, Detective, you've had a long day, and thank you very much for coming in.
Thank you, ma'am.
You're excused. Yes. If you two may please approach. Good afternoon again. So the time is now 3:12. We're going to adjourn until October 21st, 2025, and we'll meet back here at 9:30 a.m. Thank you all very much. Have a good afternoon.
Thank you.
Thank you. Good. I'm going to stop.